Hi, everybody. Welcome. I'll wait until you all quiet down to start. Thank you. My name is Yassine Eldik. I am one of the class of 2016 marshals. I'm here to introduce to you Robert Sitkoff, who is the John L. Gray Professor of Law at Harvard Law School. He's the youngest professor with tenure to receive a chair in the history of the school. He's previously taught at NYU and Northwestern. Professor Sitkoff's research focuses on economic and empirical analysis of trusts, estates, and fiduciary administration. His work, of course, has been published in the Yale Law Journal, the Stanford Law Review, the Columbia Law Review, and the Journal of Law and Economics. Professor Sitkoff is an active participant in trusts and estates law reform. He serves under Massachusetts gubernatorial appointment on the Uniform Law Commission. Within the ULC, he is the chair of the drafting committee for an act on divided trusteeship and is a liaison member of the Joint Editorial Board for Uniform Trusts and Estates Acts. He serves as an advisory consultant and expert witness in litigation and regulatory matters involving wills, trusts, estates, and fiduciary administration. He also led training workshops for trust officers and other professional fiduciary. Prior to joining the Legal Academy, Professor Sitkoff was a law clerk to then Chief Judge Richard A. Posner of the United States Court of Appeals for the Seventh Circuit. I was just irritated that he went to the University Chicago School of Law, so that kind of screwed me up a little bit. All right, all, please join me in welcoming Professor Sitkoff to give the class of 2016 last lecture.
So thank you. That's a kind and generous introduction. So I'll just say, because people often make that remark about the youngest chair, so I'll just tell you the true story behind this. I visited Harvard while Elena Kagan was dean, and while I was here, she came to my office one day after the faculty had voted and gave me a hug and said, well, I guess it went well, right? And she said, yeah, and so we sat down, we chatted for a while, and she got up and then turned around like Columbo. One more thing, if you say yes, you would be the John L. Gray Professor of Law. I said, I don't know what to say. I'm really early in career for that kind of acknowledgement. I'm really flattered. I don't really know what to say. And she says, well, it's the donation, the gift was for specialists in trusts and estates, so what else am I going to do with it? I said, well, that's fair enough. So the story of my life. I want to resist a little bit the notion of the last lecture. I know that when Jeannie Suk spoke here for last lecture, she took up the idea that she doesn't have a terminal illness or isn't leaving Harvard. But having been trained by John Manning and whatever, the last lecture, this seems textually not correct, right? There's 7 more class sessions, at least for me, this semester. We don't want to look to context. I want to resist it more seriously on the implication that somehow your legal education is coming to an end at graduation and that your relationship to your faculty and your experience here is somehow reaching a terminal point. I want to suggest that it's an inflection point. It's a change in the nature of the relationship. It's not an end of the relationship. And I want to say a word or two about why. When I came to Harvard, one of the important reasons that drew me here was the students. So I have found when I was a visitor and then joined the faculty here that I've learned from you and been challenged from you. Just the other day in class, we took a little side moment to talk about disposition of the body. What happens to most of the class about your property. Most of my class, Trust and Estates, about your property. What happens to your property when you die? Took a minute or two to say, oh, here's what happens to your body, and here's how you maybe get some control over that. And someone raised her hand. I said, yeah. She said, that's all you want to say about that? I said, well, that's really all I have to say about this. We're spending like 23 and a half classes on this elaborate infrastructure of the disposition of our property, and you're just kind of waving at the disposition of the body. This seems kind of out of alignment. That's kind of stunning. I was sort of astonished. That's absolutely right. What a great point. And why is that? Well, that's because there's been less law development. There's been less writing about it. There's been less reform on that. There have been discussions that maybe we ought to reform this. This ought to change the agenda. So in a few weeks, when I'm at one of these meetings, I'm going to raise that again. This is an important thing that you ask questions, that you challenge, and this is a thing that you should take and move on with. So what can I tell you? What can I tell you now How can I help? You know, I don't know. I have a motto, hope for the best, plan for the worst. That's a trust and estates motto, right? Hope for the best, plan for the worst. I don't really know. So I think I'm told that I know 3 things. I'm told this by my daughter. I know 3 things. So what happened, she woke me up really early one morning and said, can you make some waffles? So we went downstairs. And I wasn't really good at waffles. I'm really good at pancakes. Wasn't good at waffles. Because you know with pancakes, you have to let the pan get hot enough before you make the pancakes. The first pancake's no good. OK. So you have to be the same discipline for waffles. But I didn't have as much experience with waffles, so I didn't wait long enough. The first waffle came out all mangled and horrible. She looks at me. She says, you know, Dad, we need Mom. You're no good at waffles. Now, she's empathetic. You're not like me. I have the empathy of a rock. But she's empathetic. She sort of looks at me. You could see that on my face. She goes, no, it's OK, Dad. You're really good at pancakes. That's 1. And you're really good at trust law. So that's 2. And, you know, you're really good at love. So that's very sweet. That's 3. But you're not good at waffles. Please go get Mom. We need. So, you know, I don't know that I want to talk to you about waffles or love or trust law. What can I tell you about? So I want to tell you a little bit about trust law, but not trust law itself. I want to tell you a little bit about why I got into trust law and how trust law fits into the broader fabric of the law. I think that may have some resonance for you because while you may not be doing trust law, you're going to be doing kinds of law that has similar attributes. And let me tell you what I mean by that. What I want to talk to you about is private law. I want to talk to you about the law that governs relationships between people. Do you understand what I mean when I say private law? I'm talking about the distinction between private law and public law. Public law is the law about the relationship between the state and people. That's the law that people think about with law. It's the law that's on the cover page of the New York Times. But that's not the law that many of you are going to practice, and it's not the law that is impactful on people all the time in their interactions with other people, their most fundamental relationships. That's private law, and whether you realize it or not, many of you are going to wind up being private lawyers. I am a private lawyer. This is largely state law. There are state Supreme Courts and judges. There's a lot of important stuff going on here. I want to talk a little bit about that. I want to talk about it because it's what you're going to do. It's because of what affects people. By any rational measure of importance, this meets it. So let's talk a little bit about that. I want to say a little bit. The second thing I want to do is say a little bit about how you can affect lives deeply in private law. This should be an intuitive claim. If this is the law that governs relationships between people, it should be straightforward. It shouldn't be hard to establish that this is a law that's going to affect people in their lives and how you can do this. Do you understand what I'm saying? This is private ordering. In a literal sense, I'm talking about the kinds of law that we use to enable people to order privately their lives, their relationships with other people. And then I'm going to tell you a little bit about how within private law and within private ordering I got into trust and estates. I'll tell you the true story, not the ridiculous parody of the story I do in class. And these people want to know, so I'll give it. What's my claim? The claim I want to suggest is that it's about rule of law. I'm going to say something about rule of law. Now, when people say rule of law, they often have in mind this idea of civil society with the state providing whatever, and they'll often speak about the peaceful transition of power after presidential elections and governor, and so that's what people think about when rule of law. My understanding, I think rule of law is something, for me, much cruder and more visceral. For me, rule of law is more about the infrastructure to allow people to order their relationships with other people in ways that are meaningful and important for them. And on this view, what others are thinking about rule of law, this public law, is infrastructure to enable a private law regime to allow you to order your relationships and your lives in meaningful ways with other people. All right, that's going to be the claim. So what am I talking about here? OK, so public law, right? Public law in this view is infrastructure. Public law is the law that enables the state to provide mechanisms and rules so that you can order your affairs. So what do I mean by ordering your affairs? Well, let's play sort of armchair philosopher for a moment. You know what I mean by sort of philosopher, sit back. What is the good life? What is the nature of people and so on? OK, so if we're going to move into a civil society, you want to move from state, let's do it in a minute, right? You want to move from civil society, you want to move from state of nature into civil society. What does this entail? Well, as a rough approximation, it entails a property right in your person and in your stuff. Roughly speaking, I don't mean that literally. I mean, just roughly speaking, you have some kind of property domain control over your person and over your property. And you want to organize the interaction of your person, your property with other people. These might be voluntary undertakings is contract. So not also contract, so marriage and others, but basically contractual undertakings with other people. And then you have to deal with involuntary arrangements. That's tort, right? Your involuntary exchanges of these rights to your property and your person and your stuff. That would be tort. Now, I'm an American, so I'm going to ignore unjust enrichment. But that would be part of what a continental lawyer would call the law of obligations, part of this. Law of unjust enrichment is a kind of way to regulate how far we go with tort and with contract for unjust enrichment and the like. Now, I don't, by stressing this as fundamental building blocks, mean to denigrate public law. Public law has exploded in importance and relevance. Our new curriculum, which has legislation regulation, the first-year course, is an acknowledgement of the deep, pervasive influence of public law. I just mean to say, don't take that as a diminishment of the significance of private law to everyday interactions of people. So what do I mean by this, and why is this important for you? So what are you going to do in practice? What are many of you going to do? I'd like to be a social scientist. I should have gone to OCS to get the data. I'm confident that a majority of you will ultimately wind up in private practice for individuals helping with private ordering. What do I mean? I'm talking about corporate practice. Corporate practice is private ordering. When people form an LLC because they're making a new business, that's a contractual organization. These are private employment. What about if you get married, right? Marriage, family law. These are private ordering within the most intimate kinds of human relationships. In a liberal society, I mean that now, small l, liberal. In a liberal society, this is what rule of law entails. Rule of law entails facilitating the interactions, relationships between people in this way. So what follows from this? So one vision of what a lawyer does on this view is a kind of a transaction cost engineer. What do I mean by this? So say you have two people and they want to get married. This is a kind of fundamental, important relationship in life. We have a legal infrastructure to allow for that. So what would be the role of the lawyer helping two people getting married? Well, suppose a later in life second marriage and their children from earlier in life, and there's wealth accumulated in the earlier first marriage. It's a common fact pattern. There's a common repeating fact pattern. What would be the role of the lawyer in this relationship? Well, we're going to change all the default rules of marital property, right, by premarital agreement for these folks, so that later there's not a dispute between the stepchildren and the surviving step-parent and the like, if we plan for that ahead. So there's a famous line of literature that speaks of lawyers as transactional cost engineers. Another way to understand this is that you are the private ordering kind of assistant. You're counseling in this way. So what do I mean by this? Your clients have a purpose, right? They have a reason. There's something important to them about their relationship with other people, right? It could be a business relationship, buying widgets. It could be a personal relationship, getting married. It could be an employment relationship, hiring the plumber. Everything they do is relationships with other people. They have a purpose, a policy, something they're trying to achieve in that relationship. Your role is to understand that and use these tools. And by tools, I mean the underlying law, but also the tools of legal interpretation and application to get at what they're trying to do. So what do I mean by this, and why does this matter when I suggest the feedback with the law? So here's an old historic example. There was a time, I'm going now back feudal, there was a time in feudal England when property persons wanted to secure their property down the generations for their family. Right? They would do this in what's something called an entail. How many of you have heard of entail in property class? Okay, so speak to the entail. You know what the entail is? This would be like to my male heirs forever down the generations. Right? I take Downton Abbey and I give it down the generations for my male heirs. So what happened? This raises a kind of public policy question whether we want people to be allowed to do this. By way of statute and judicial decision, the law broke the entail. Right? Law breaks the entail so that you can't arrange in that way. So what do the lawyers do? Lawyers found another way to resurrect the entail. They came up with future interests. So what came next? The formation of the law future interest to defeat that. So then lawyers figured out we can come up with executory interest to get at the entail. The particulars don't matter. The point I want to suggest is that there's this feedback loop between law and what the lawyers were doing to achieve the purposes of the client. So why am I emphasizing this? You have all these tools. You understand governance by rule versus governance by standard. You understand the significance of plasticity of language, of text and context. When you got an email saying Sitkoff's last lecture, you didn't need to be told that I was going to die, not dying tomorrow, right? You knew that from context, right? You understand how to do this sort of interpretive point. You understand how to use this in litigation. What is the purpose that you're doing this for? It's often to achieve the client's end in their private ordering. So let me give two contemporary examples, and then I want to say a little bit about how this has played out for me in trust and estates, and then something for you going forward. So here's a contemporary. We're examples that I see regularly. It is a common mistake in practice for lawyers to put cliff escalator clauses in premarital agreements. So let me tell you what I mean by that. So you have a premarital agreement that says, if the marriage dissolves within 5 years, I pay you $5 million. If the marriage dissolves within 10 years, I pay you $20 million. You understand what you've just done? You've a high power incentive for divorce at year 9.5. Right? You're done, right? The idea, a lawyer who was a transactional cost engineer, who understood what the lawyer was doing here was it was private ordering of this intimate relationship, would have paused and thought, I don't know that I'm creating the right infrastructure. I don't know that I'm creating the right incentive structure here. Or here's another one. It is not uncommon to see dispositions in family wealth transfer that depend on the number of children in different family lines. And you could see why, from a fairness perspective, you might want to do this. I might say, I've got children, and they have children. This family line has more children than the other. I'm going to have a formula, and I'm going to give different family lines more or fewer kids. Right? You understand that's going to have a feedback on fertility, right? Or on adoption, or strategic adult adoptions. Right? If you anticipate this in advance, you will help your clients achieve their private ordering goals, right, without the perverse incentive that will undermine the purpose for which they've come to you, which is for help in ordering intimate, critically important things to their happiness, which is to say their private ordering in their lives. OK, so what does all this have to do with trust and estates for me, and what can I suggest for you going forward? All right, so how did I get to trust and estates, and why did private ordering become so important for me? I want to say, in truth, it's overdetermined. In class, in various contexts, I've told people the funny story of doing wills with my dad, and I'll say something about that. But there's more. There's a story of seeing this in action with early deaths in my family. There was a kind of serendipity and something that happened at the University of Chicago with me, and I'll tell you that story too. And you put this all together, and it gets overdetermined, and then I'll suggest some lessons for you. So the funny story, right? What's the funny story? The funny story, which is true, is that when I was a kid, I used to type wills for my dad. My dad couldn't type, right? So he'd write these things out, and I'd sit there with him at the computer, and I'd type that out, and we, make various changes. And so, I had friends, they'd go play ball with their dad. We would play kill the client's family. Like, we wouldn't actually kill the client's family. We would draw a family tree, and we'd start killing people off in different orders. Why did we do this? Because we wanted to make sure the instrument provided for every contingency. So, Dad, why do we need to do that? Why do we need to provide for every contingency? Because if we don't, the default rule of construction applies. What's the default rule of construction? Well, if we don't provide for this, then it's going to be this default rule provided by the law, which could be this or could be that. But we know what this person wants, so we're going to provide for it. We're going to provide for it specifically. Right, so what do you get from this? Right, so already, right, there's 12 typing these things, appreciation for the significance of the choice of lawyer and the quality of the lawyer in understanding what the client was trying to achieve and planning for all of these eventualities. Right, so what does this mean? We talk about, in my class, it's all about freedom of disposition, what the donor wanted, kind of push the donee to the side. Just that's really kind of a parody. The donee is important because that's what the donor wants. Why am I drafting this will? Why am I typing this will? It's because this person wants a certain arrangement for their survivors. This person is deriving benefit, happiness, utility, however you want to, whatever social science you like. This person is deriving happiness and benefit from knowing affairs have been arranged in a certain way after death. That's what we are. That's what we were trying to do. Okay. The other thing I got out of this was, from time to time, someone would have a crazy idea, or an idea that wasn't crazy for them, but they hadn't thought through the consequences, like treating children unequally. And this would involve sitting down with the client and saying, you can do this, but the kids aren't going to talk to each other, and there's going to be a lawsuit, and you really need to understand the consequences of your decision. right? And I can help you see this because I have an information asymmetry. I'm the repeat player. I've helped 100 people order their lives in this way, and I've seen how it goes wrong. And I want you to learn. I want to help you understand how this can go wrong. OK, so that's the sort of longer version of the funny story. Now, here's the rest of the story. When I was 17 in high school, my mother died of ovarian cancer. She was diagnosed with ovarian cancer just under a year earlier when I was a junior in high school. So what do, right? Your mother's diagnosed with ovarian cancer. When you're 16 in high school, ovarian cancer is pernicious. It's sort of invidious. It moves very, very quickly. And especially, this is now more than 20 years ago, especially then high mortality rates. So what do we do? Well, on a personal level, this is brutal in a variety of ways. I was very close with my mother. Wasn't as close with my father, though we typed wills and we did this stuff. Let me sort of give a side note. So my father grew up in really poor in Brooklyn, right? So immigrant family, grew up in Brooklyn, as in the Marshalls came and took away the furniture once for not payment of debts, kind of poor. So my father's mission, he was a lawyer, was this is never going to happen to him and his family. So he worked all the time, right? How did I hang out with him? I typed wills with him. That was work. OK, so my mother got sick. So what do? Well, you go to doctors. You try to investigate this. What else do? You have to hope for the best, but plan for the worst. We have to be ready for this. So among the wills I typed for my dad was my mother's. We sat there and we typed this whole thing. We typed the whole thing out. We made the plan. Now in class, I joke when I turned 18, we went and executed my will, because that's what you do when you turn 18. You go register for selective service if you're a guy, and then you execute your will because now you have testamentary capacity. Now you're 18. That's not the whole story. The rest of the story is we also executed a codicil to my father's will, because by this point my mother had died. We executed a codicil to my father's will to name me as guardian of my brother, to keep his sister, my aunt, who lived in Delaware, we were in New York, as trustee. She would be in charge of the money, but I would be guardian. Why? Well, because I would transfer to a college in New York, and we wouldn't uproot my brother. Now, I understand for some people this sounds like a grisly, gruesome, kind of horrible thing. For me, it was a source of extraordinary comfort. For me, it was a sense of, I'm going to hope for the best that my mom won't die. That she did. I'm going to hope for the best that my dad won't die anytime soon, but it could happen. Winter is coming. I know. I have experienced it. It could happen, right? Bad things can and do happen. One of the roles in helping your clients do private ordering, in doing private law, is you're the one who has to say, bad things could happen. Let's plan for that. Well, let me say this another way. Why do you enter into a contract? You enter into a contract only for if the bad thing happens and you need judicial enforcement. As long as you're in an ongoing relationship, the contract is irrelevant. Right? Why do we do these private ordering arrangements? For when bad things happen. OK, well, I know that parent can die. I was there. I saw this happen. So for me, at 18, this was hugely reassuring. And for my brother also. My brother's 12 at the time. So what happens if you get sick now and die? Because I know that could happen. I just saw that. Here's what's going to happen. You're not going to have to move. You're not going to have to change schools. Rob will come home, and you'll stay here with him. This happens to people. Have you heard of the author David Eggers? Right? Wrote a book, A Breathtaking Work of Heartbreaking Work of Breathtaking Genius, whatever. Right? That's this story about this happened. Both of his parents died. He took care of the youngest sibling. People do this. Right? If you hope for the best, plan for the worst. That's what we did. For me, this is a really powerful and searing kind of experience of the role of a lawyer, the role of law in providing for private ordering. I didn't know that vocabulary then, but that's what we were doing. We had a little meeting. My dad explained to his sister, I don't want you to resist Rob being guardian. You're going to handle the money, but he's going to take care of Jeremy so he doesn't have to move, and the whole kind of story. It was very, very helpful, reassuring. This wasn't all, though. It's kind of, then, as I went off to college, my mother's mother got sick. Now, my mother's mother, her daughter, my mother, had just died. The other piece of the story is my mother's sister also just died within a few months of my mother. So my grandmother, who now got sick, both of her daughters are dead. I was her only adult descendant. I'll say this again. My mother's mother, she's got 2 daughters. They're dead. I'm now 18. I'm her only adult descendant. My brother is turning 13 now. So she got sick, right? We went running to the hospital. I came in with health care proxy. Well, who are you? I'm her grandson. Well, where are her daughters? Where are their children? They're all dead. Here's my healthcare proxy. What's going on? What are we going to do? It was the same story. For us, this was like really important. This was the way in which, I understand a sort of psychological level, it's assert control, that's not really true, and whatever, that's not my domain. It was, we had a plan. We were ready for this. We were ready because we understood this. She is going to get sick one day. Now, I didn't expect that day to be the next day, but we were ready, and we took care of her. And again, it was the same story. Now, those of you who were in my class last semester especially heard me use the example of my father getting sick this last summer. I don't mean to suggest like my whole life is people getting sick. There was like a nice 20 years then in between. My father got really sick this summer. My father was intubated and unconscious for a few days. He's vertical again and walking around and up to his usual stupidity. I understand this is on YouTube. He knows that's what I think. So it's OK. So, but let me tell you what happened when my father got sick this summer and he was in the hospital unconscious. My middle daughter, who's 6, said, wait, Dad, I have a question. Who's in charge of Grandpa's house if he's in the hospital? You said I couldn't talk to him on the phone because he can't talk. That's right. And he's not allowed to walk around. That's right. Who's in charge of his house? I said, well, that's a great trust in the state's question. I'm going to explain that to you. I'm in charge. Why are you in charge? Well, because we knew that one day he'd get sick. We made a plan for it. And so and she was kind of relieved. She said, OK, well, then that kind of makes sense. She says, actually, if you're in charge, why don't you go throw away all his bad food that makes him sick? Which is part of my dad's like the world's dumbest adult diabetic. But that's a separate issue for another day, right? That's hope for the best, plan for the worst. That's personal, right? OK. It was against that backdrop. It was against that backdrop that this is what happened. I was in college. I wanted to go to law school. And I had decided I was going to go to Stanford. And I was ready to send the money in. It was all set. I was on my way to go to Stanford. I had 2 professors in college who arm-twisted me to go to Chicago instead. They was just really aggressively, heavy-handedly, were really twisting my arm to go to Chicago instead. One of them said, write this down. Mark my words. Go to Chicago. You're going to take in with law and economics. You're going to get a good clerkship, and then you're going to teach. This is like your first best destiny. It's sort of obvious. This is what you need to do. And so here's a sort of life lesson. These professors, they'd been around the block. I was 18. I was 21 or whatever. I was 21 at the time. So I took them seriously. I took them seriously enough to go visit the schools and sit in. Right? Here's a little lesson. You know a lot, and you have a lot of energy. You don't have that much experience relative to someone who's now in middle age or later age. They did. These guys had been helping students like me figure out what to do next for 1,000 years or whatever. So I took them seriously. And I went off, and they were right. I went and visited, and it was clear to me it was the right fit. And so I went there, and it was I loved it. I had a great time and a great experience. I had professors like Mark Ramsayer and Cass Sunstein, Adrian Vermeule, and Jack Goldsmith. It's familiar, right? It's all true. I had one, and I even had a guy named Barack Obama for constitutional law. Anyway, it was you've heard of him, right? It was a very exciting, interesting time. For me, I found law and economics. I also, through a friend law school, found Tamara Scheinfeld, who's now my wife. I also refound trust and estates, and let me say what I mean about that. So I had in the back of my mind I might want to teach because this professor had planted this idea. I had this in the back of my mind. And I took corporations, and it was like the sky fell. This agency problem, shareholder, manager, I got it. It fit. It was exciting. I had lots of ideas. The political economy of the corporate law reform, competition between the states, and the race to the top, race to the bottom with Delaware. It was also intuitive. It kind of fit. It made sense to me. The professor who was teaching the class was an important figure in the field, had a robust and huge consulting practice, and was not really around to kind of mentor or talk to students. This turns out to have been enormously beneficial for me, right? That fortuity was really, really important. Why? Because I didn't turn into a corporate law person. What happened then was I took trust and estates. I said, you know what? It's time. I should actually take the class. So I took trust and estates, and then the sky fell again. So we do intestacy. That's the law of what happens to your property when you die without making a plan. This was super intuitive to me because I had a feel for what people wanted. I'd been through that. This idea of these are default rules, and we have to figure out what people want. It's complicated. It made so much sense. And then wills. This also made a lot of sense to me because I used to type this. The jargon wasn't wasn't a barrier, except now I was thinking about it like a one-party contract, and in contract consideration is the formality. We don't have an exchange. This is a unilateral private ordering. This is me giving it. We need different kinds of rules to make that work. And non-probate transfers are sort of fascinating. There's market competitors to, free market competitors to public systems of succession. That was a kind of, wow, that's kind of neat. That we now have private ordering as opposed to publicly provided private ordering. That was kind of exciting. And then trusts happened, and that was it for me. It was it. It was the agency problem in corporate law all over again. Oh, there's an agency problem. We should think about agency costs. And nobody did that. There was no mention of agency or agency costs in the casebook. The phrase agency costs, I did a Westlaw search. The phrase agency costs appeared like in one article. So there was no one was doing this. I said, well, this is it. This is what I'm going to do because this feels right. I understand something about this. And then comes serendipity, right? So here's the piece of serendipity. At the time I was at Chicago hired a new professor named Lisa Bernstein. Lisa Bernstein is a specialist in contracts. She made her name by undertaking studies of how people do private ordering around contract law. Her first paper, which she wrote when she was a law student here, was about the diamond industry. She went to the diamond industry in New York. She looked at how diamond dealers resolved their disputes. And what she found out was they resolved it privately with a lot of formality, completely contrary to what the Uniform Commercial Code provided. Then she did this with wheat growers, and she did this one industry after another, right? She was all about private ordering and how people came together to arrange these relationships in a way that maximized their welfare with or around the law that was provided, right? So she shows up. Well, how is this serendipitous? She shows up, and a friend of mine invited her to go to Passover Seder at her parents' house because Lisa had just shown up in town, didn't really have an infrastructure there. Lisa says, well, I don't drive. I'm from New York. I don't drive. How am I going to get all the way to your parents' house? Oh, I'll send Rob to go pick you up. So I picked her up. Who are you? I'm Rob. What are you doing? Well, I'm a law student here. What do you want to do? I think I might want to teach, right? Well, it turns out another thing that Lisa Bernstein likes to do is help people get teaching jobs. And so she says, well, what are you interested in? Well, I had this idea about trust and estates. Why? So I started talking with her. And I didn't have the vocabulary to say private ordering. But you see how I walked right into her wheelhouse, right? It was a perfect, walked right into her wheelhouse. So what happens at this Passover Seder, there was a rule. All people who showed up had to interrupt the Seder at some point and contribute something creative of their own. So what did I do? Well, if you know the Passover Seder, they're the four children, the wise son, the simple son. Okay. So I interrupted, said, there's the fifth child. Oh, yeah, what's the fifth child? The fifth child is the Chicago-trained child who wants to know if there had been enforceable contractual opportunities so that this bilateral monopoly negotiation between Pharaoh and Moses could have been enforced with something other than plagues. We would have had welfare maximum. We wouldn't have had unleavened bread. There'd be time to leaven it. Blah, blah, blah. She thought this was awesome, right? Because it's all about private ordering. You're taking Passover, making it about private. I understand there's a kind of deeper story of slavery. I get that. But the point, she was. So what came next? She says, "Okay, you got to do this, right? I'm going to help you get a teaching job. I'm going to help you get a teaching job because this would be a neat fit." Okay, so I clerked for Judge Posner right after graduation. So while I was clerking for Posner, that was my only year, I should say, outside of law school since I was 22. You realize since I turned 22, I spent 1 year not in law school, and it was a few miles away from a law school clerking for Judge Posner, a former professor at a law school, right? Okay, so. I told him about some of these ideas. And one worry when you have all these ideas and nobody else has done it, no one else has seen it, is that you're just nuts, right? He said, no, these sound good. You should kind of work on this, right? So meanwhile, Lisa Bernstein, she tipped people off at Northwestern that there was this guy who had graduated, had good grades, he was clerking for Posner's in town. Why don't you kind of have lunch with him? Next thing I knew, I was giving a presentation to the faculty, and they were voting me a tenure line appointment. So I was 25. I was clerking in Chicago. I was single. They were telling me that Northwestern was a bit right, probably would be best case scenario if I went on the formal market. So this is perfect, right? It's everything I wanted to do. It kind of all made sense. So I went to Northwestern. While I was there, I spent the first couple of years just figuring out which end was up. You know, I turned 26 the day before my first contracts class. The whole thing I didn't understand what I was doing. It was a whole kind of big, it was a whole mess. So I spent the first couple of years figuring out what I was doing. And I did a paper called An Agency Cost Theory of Trust Law, right? This idea that had fallen from the sky, that had been on my mind since law school. It took me years to understand how to do this, how to explain it. There is more of that article on my hard drive than that was published. You understand? I wrote hundreds and hundreds of pages trying to figure out how to say this and what this was. So that was one thing that happened. Today, you can't do trusts in American Legal Academy or scholarly work or now in practice without running into agency stuff, right? Because it got it out there, right? OK. That's one thing that happened. That started work. The other thing that happened was my friend Max Schatzenbach. So Northwestern hired a guy named Max Schatzenbach, who's my best friend in the Legal Academy. So what do I mean by that? Like on the speed dial in my office, it's got my wife mobile, my wife home. Then it's got Max office, Max mobile, right? So it's above poison control for Seinfeld friends, right? So all right, Max on that. So Max happened. Max is a well-trained empiricist, a JD, PhD in economics. So he came to me and says, you know, why don't we see if we can't do an empirical study? You're saying all these rules are changing, this private ordering matters. Let's see if we can test that. I said, oh, well, you know, the thing that occurs to me is the rule against perpetuities. You understand how exciting this is? He's an econometrician. He says, I want to bring econometrics to trust and estates. I said, I know. Let's do it to the rule against perpetuities. It's like chocolate and peanut butter, right? Econometrics and perpetuities, what could be more exciting than an econometric analysis of rule against perpetuities, right? We giggle about that. OK, this is a 2005 study. We found $100 billion moving states because of abrogation of the rule against perpetuities. That was astonishing, right? That was a kind of wake-up call for me. We found $100 billion changing states because of this change in the law. This was the beginnings of, for me, now, of not just doing theory, but kind of starting to look outwards. This is the beginnings of a wake-up for me. Oh, my goodness. This is really affecting a lot of people in a lot of ways, right? This really matters. The people are changing their private ordering in light of how we are changing these rules. And that $100 billion, that was, by the way, through 2003. And that was a sample, not population. So the real number is way bigger. That's a big deal, right? So we did another paper about trust investment law, and we found portfolio allocations changed with law reform. This is a law reform by the American Law Institute, the Uniform Law Commission, to which I'll return in a moment. So what did that do? That told me, that was a kind of idea that this really matters. In addition to teaching and scholarly work, I want to start thinking about now the law reform. And so now this brings me back to you and state law and private law. There's I think, an undue emphasis, and I understand it's a normative claim, but I'm comfortable making it even on video. I think it's a kind of undue emphasis among various law school events, leadership, and the like to kind of denigrate private law work and to suggest that the only meaningful role for lawyers in contemporary society is in reworking public law in a public interest sort of way. And I want to say that I don't think that's right. I don't think that's right empirically. And I don't think that's right normatively. And I say this as someone who, when I was 17, was freaked out that my dad was going to die, and we didn't have a good plan for that, but then we did, and it was OK. I'm telling you, I know in my heart, I've lived it, the importance of private law and private ordering for individual lives. And then in my scholarly life, I found out, it was right in my face, that this really matters. It's like changing the way people organize their lives when we change these rules. So what does this matter? So I'll say something about what I do. Then I'm going to say a word about things you can do. And then I know we got to stop so we can go to class or whatever. One of the things that I was motivated to do after these studies was to get involved in law reform of these private law topics. And I want to suggest a reason why it's so important. And then I want to suggest ways in which you can do that. So why does this matter? The traditional mode of law reform in private law is common law adjudication. You know, you have a bad rule, you litigate. A bad rule, you litigate. A bad rule, you litigate. You litigate it enough, eventually the rule changes. I don't know that that is as efficacious as it used to be for a variety of reasons. One is I think our market and our economy move so much more quickly now, right? Because we have new technology and like, we just move more quickly. I don't know the common law in the ordinary common law process can keep up. I also think that many of our best minds are being sent to public law and to federal practice, instead of thinking about state law and private law and these other areas. Another way to say this is, if we were doing this 50, 60 years ago, there'd be various of you in the room thinking about, I would love to wind up a state Supreme Court justice. I don't know that any of you even thought of that yet, though I suspect some of you thought about federal circuit court judge. So one reason is I think we're moving too quickly. Another is we're just not paying attention in the same way. And I don't mean to denigrate state, but some of my best friends are state judges. That's true. I mean to say that it's just not on the radar in the same way in the kind of elite law circles in which you will travel. So why does this play out? I think this makes organizations like the Uniform Law Commission and the American Law Institute more rather than less relevant than it had been in the older days. So why is the Uniform Law Commission puts out things like the Uniform Commercial Code? How many of you have an iPhone or an Android phone in your pockets, right? You bought it, right? Welcome to the Uniform Commercial Code. Like anything you have ever bought, this is everywhere. Okay. Why is this so important? What these organizations like the ALI or the Uniform Law Commission does is it brings together a national level experts to pool its understanding of problems and to say, here's a new development in practice, a new development in technology, a new development whatever. Here's how we can change our rules to account for them so that people can do their private ordering in an efficacious sort of way. Right? So what does this mean for you? Those of you who are going to wind up doing private ordering through private law, you're going to develop deep expertise in limited liability companies or bankruptcy or contract or tort or agency. You're going to have deep understanding in business organizations and all these different areas. And you are going to come upon developments in your practice for which the law does not provide good default rules, for which the law has interfering mandatory rules, for which you're getting wrong outcomes measured by what people are trying to do in their intimate relationships. It will be your responsibility to fix that. It is not, no one's running for governor for that. No one's running for president for that. How's that going to happen? You're going to have to go to your state bar association. You're going to have to be a part of the business law section or the contract law section or whatever your state bar association and hope that your legislature will respect that expertise and make that change. You're going to have to explain that in your briefs when you litigate the court. You are the lawyers. You are, in a sense, the public servant, but here as a guardian for the law that governs people in their most intimate relationships. So why is this lecture today and not tomorrow? Tomorrow I'm leaving. I'm going to be in Chicago for a meeting of the Divided Trusteeship Committee, for which I chair. And what is on our agenda at that meeting? We're going to look at the most recent draft of the Act, which John Morley, who teaches at Yale, and I put together. And what is this Act all about? This Act is all about providing statutory default mandatory rules to grapple with the new phenomenon of people creating trusts that have multiple people who are not trustees involved in the administration. If we could go back in time, when I was 17 and my dad was making an estate plan for what would happen if he died, we would have used divided trusteeship. Why? Because I was 18. I wasn't ready for a lot of those responsibilities, but I was ready for some. He would have divided it up. And so why is this so important to me? It's important to me because my daughter, who tells me that I'm not good at waffles, but I'm good at pancakes, I'm good at love, I'm good at trust law. My wife and I could die tomorrow. And then I need that divided trusteeship arrangement in my estate plan to work. Why? Because this is private ordering. This is private law. These are our most intimate relationships. If you're a lawyer and this is what you do, this is essential for civil society. So if this is my last lecture, that's what I want to say. But I don't want this to be the last lecture. I'm over in Hauser. You know how to find me. And there we go. So thank you very much.